All right, for more insights then into this issue, we're now joined by legal expert Modidima Mannya. A very good evening to you. So thank you so very much for joining us here on SABC News.
Good evening, and good evening to your viewers.
All right, let's start here. So I guess then this means it's sort of all systems go for the main trial. I'm talking about the arms trial without what has been called throughout distractions and delay tactics.
Yes, certainly. And I think that the response of the Zuma Foundation that the judgment is bizarre, that comment itself is very bizarre, I must say.
Why do you think that?
Look, this was never going to see the light of day. If you recall, this matter, part of it was heavily ventilated before Judge Kuhn in the special plea arguments. And amongst others, the complaint was the alleged leakage of information or medical records or health information. And Judge Kuhn had found that the document which is alleged to have been leaked to Karyn Maughan said nothing regarding or contained nothing regarding Mr. Zuma's health condition. But secondly, this very issue was debated because the allegation that the document was produced before it was a court document was not correct. In fact, what happened is it was attached to an unsigned affidavit, which is normal practice when we deal with matters on an urgent basis. We do submit unsigned affidavits and later submit signed affidavits. But this particular court has found that the actual publication happened after the document, the signed affidavit was filed, because this was an annex to a founding affidavit.
Yeah. All right, so a part of what we then heard was, of course, that this is also an abuse of court process, an abuse of processes, is what we were told. What does that necessarily mean? I mean, for as long as those processes exist in law, how can there be an abuse if you're exercising your legal rights and exercising, opting to choose what's available to you? Then there would be a problem within the law itself, the fact that these processes then do exist. So, is this basically saying you can't use processes that are already there to one's disposal? So what does that mean, abuse of court processes?
Well, let me try and simplify it, Flo. All of us have rights. The rights are guaranteed and entrenched in the Constitution.
Correct.
But none of them is absolute. So you're not going to say, I have a right to sing, and then you go and sing in Flo's ear and say, it's my right to sing. The same applies to court processes. They are there for legitimate purposes only, not for ulterior purposes. And one of the findings you will see in the judgment, the court dealt with the issue of the ulterior purpose of Mr. Zuma in making this application. So the abuse of process comes when you approach a court for a purpose other than a legitimate purpose to assert your rights, because Mr. Zuma didn't have any injury in this matter. As the court has found, and I think it's very obvious, that his lawyers and the state lawyers, the prosecutors, all of them had the same document which was attached to their affidavits. So I don't understand how you could blame them for publication. And I think that is what constitutes an abuse. In legal terms, we call this vexatious and frivolous. That is when you do something just to annoy another, not because you want to assert a particular right or protect an interest. Yeah.
Is there further legal remedy that would then be available, or have all legal remedies at this point pertaining to this particular issue been exhausted? Is it fair to say that everything has now been exhausted when we're talking about this particular case pertaining to the journalist Karyn Maughan as well as the prosecutor Downer?
Well, let me first put it this way. The court has found that there was no certificate declining to prosecute Ms. Maughan. So in the first place, that means, and I think going back to the abuse of process issue, it simply says you go to court, you know there's no certificate. The court interpreted what was presented to it as a purported certificate that covers her and found that that is not the case. The court has probably went further to say, look, you will not pursue this thing further. I think in many instances where you have people who are called vexatious litigants, the court often, and that is based on the inherent power of the court to regulate its own processes, do stop such people from abusing process.
Yeah.
So this may be the end of the road. I'm not sure about what the opinion. I don't think there's even the slightest possibility of another court reaching a different conclusion on this matter, having read the judgment.
Yeah, is there any kind of precedent that this would then set? I think that, you mentioned the fact that, everybody had the same documents that had been attached. But I think what had sort of been the argument was that, in one instance, and I mean, we're talking about, a balance here, the scales of justice, where, we have to weigh one right with another. In this particular case, I think that part of the argument was, the right to information, the right to access information, the right to freedom of speech and so forth, but also balanced on the other side against the right of privacy, the right of, not having one's medical conditions released out in the public domain. Let's just say it was a kind of a situation. On which case would it have favored? Which one weighs more? Is it the right of a person to their privacy, to their dignity, to so forth, or would it be the right of information, the right to freedom of speech? Where do you see that, and what precedent may this then set?
Well, the principle is that at all times the court strikes a balance when there's a conflict of rights.
Correct.
But that does not even arise in this matter, because in this particular instance, as the court has found, there was nothing wrong about this document. It was a public document, by the way. What Ms. Mon did was just to put it on a media platform. Once documents are filed in court, they are public records. They are public documents. Flo, you can go to any court yourself with a case number and access a court file of any matter which has not been declared to be confidential, and where the public
so that wasn't necessarily. So that wasn't necessarily my question. That wasn't my question. My question was really about when you were weighing up the two rights, right? Which one on that scale, right, weighs more? Is basically what I'm saying. I'm parking this particular case for a second, but I'm asking you just objectively to look at the two matters that I've raised. I'm asking you which one on that scale of probabilities would then balance more. I see you smiling, but my question remains. Yeah.
I want to answer you as a lawyer, because the law applies to the fact. But let me put it this way. As I said, in law, there has to be a balance if there are two competing rights and interests, Now, the court would have found against anybody who publishes the medical condition of another, that would be an infringement. And the right to information cannot trump over that right where there is unlawful conduct. So at all times, the exercise of rights...
Yeah. All right. Well, let's wrap it up. Thank you very much. You've given me the answer. That is Modidima Mannya, legal expert. Thank you very much for giving us your time there.